Hello, everyone. Thank you for joining the Hidden Costs of ACA panel discussion. Today we have with us a few folks to discuss this. Just as some notes before we get started here, everyone is on mute. Please submit your questions. There are moderators attending this conversation. And before we dive too much into the details, let's hear just a very brief introduction from each of the presenters. Leanne, would you mind getting us rolling?
Yes, definitely. Yes, my name is Leanne Havlicek. I am the manager of the Employee Benefits and Retirement Operations Department at Merit. I have 10 years of employee benefit experience, and I'm happy to join this today.
Thank you. Sarah?
Hi, I'm Sarah Charlier. I am an HR business partner here at Merit. I've been with Merit for 10 years now, and in HR for about 15 years. So happy to be with all of you this morning.
Thank you.
Hi, I'm Tom Seltz. I am not with Merit, actually. I'm with LMC Insurance and Risk Management, but we partner a lot with Merit and are good working collaborators. I am in charge of regulatory analysis. And I've been in the insurance biz for, 24 years or so now. I previously worked for a firm in Washington, D.C., and got a front row seat when they were actually debating the Affordable Care Act and then when it was finally passed. So I've been really focused. I've focused on lots of things, ERISA and HIPAA and other things, but Affordable Care Act is my bread and butter, and that's pretty much all I do right now.
Well, lucky for you, we'll be talking all about it for the next 30, 45 minutes. Before we start the question itself, which is the next question we'll be having is where are the hidden costs, we've kind of formulated some of how we're going to answer this into a few buckets, so to speak, in a few areas. We've got compliance, strategy, and implementation. And so as all of us start to answer the question, you'll start to hear that come through in this conversation. Now, Sarah, if you don't mind, let's start with you. Where are the hidden costs?
So one of the hidden costs I think some folks don't consider is just the time. The time it takes. Time is money. Your employee's time is your money. So really being able to sit down and sort out what you need to do and when you need to do it before it becomes an emergency.
Yeah.
I think time is, you spend a lot more time when you're trying to scramble to put your compliance pieces together. And there's so many pieces to put together. I think that's one of the things that companies aren't realizing really quickly is how many things you might need to change in your day-to-day operations in order to be compliant, or just to make it easier to be compliant when your reporting periods come and when your employees become eligible under the regulations. For example, making sure you're able to pull the hours worked by month for your reporting, or that you're tracking paid leave time or unpaid leave time that's protected as hours worked. Because you don't pay them, you kind of forget about your obligation to track it under the Affordable Care Act. So there's a lot of places where time comes into play.
And really, when you think about how much time it would require as an employer to keep up to date, that is time that you're taking away from your business and improving and moving forward, and that is definitely a huge cost to you. And and if you decide, okay, I'm going to hire somebody specifically to take this on, well, then you really have to consider, let's say this employee changes jobs, is no longer at your company, then where are you at?
Right. And you're starting to touch on some of the strategy and implementation aspects. But let's dive a little bit into that compliance standpoint.
Sure.
Maybe some of the penalties that A and B have.
Yeah, I don't know that they're hidden costs, but I think they're plain and in the text. But what's hidden about them is kind of how tricky they are and how really either you or someone who works for you needs to really master the details in a way because there's some little gotchas that can happen. When I see people make expensive mistakes and then have costs that were previously hidden to them, it's often because they're trying to combine different parts of the rules into sort of like this unified field theory of the Affordable Care Act, and so, or worse yet, sometimes trying to create some sort of philosophical underpinning so that they can understand the point of all this, so that they can, so they don't need to know the rules. They understand the purpose of it, and they can just make it up as they go along because they understand what it's for. Well, in this case, that's always dangerous anytime you're talking about regulations, frankly. But for the Affordable Care Act in particular, there's what makes sense and kind of why things are happening, and then there's just what the rules are. And oftentimes the hardest questions that I have to answer are questions like, why are we required to do this, or why can't you do it this other way, or something like that. So I'll give you a good example. There's two opportunities, we'll call them, for employers to have penalty under the employer shared responsibility provisions. One is called penalty A, that refers to the Treasury Regulations section 49 to 80H section A, and then there's penalty B. And a lot of people have trouble, they want to combine them for some reason. So a great example is penalty A has this de minimis rule. So it says that an employer will be subject to a penalty if they fail to offer coverage to, and this year would be 95% of their full-time employers. So they know they've got that 5% wiggle room, which is great. You can use that 5% intentionally or accidentally or in any combination thereof, but they know about that 5%, and that gives them some kind of comfort. So they might say, well, I can make a mistake, or I can exclude this people or something like that, which is fine. But they're forgetting about penalty B, and penalty B doesn't have such a thing. The first person, if you have a full-time employee who gets a subsidy on the exchange and you failed to offer them coverage that was both minimum value and affordable, and there's those are all loaded terms we could talk about at length, by the way. It doesn't matter that they're in that 5% or not. That's a completely separate subsection of the rules, and so it's not hidden to those of us who are dealing with this on a day-to-day basis. But for somebody who, you know, their real job is running a business and compliance and regulations isn't their main thing, I could see where those nuances could get lost pretty easily, and that could have a huge hidden cost to them. But when it's time to do their taxes a year later.
Yeah, thank you, Tom. You know, like you touched on, running a business and regulations are not their main thing. Those are two disparately different things. And a big part of what Merritt and what Sarah and Leanne are doing is working with those business owners, handling a lot of that regulation on their behalf, and the administration and the tracking and record retention. We'll touch on these along the way, but if you all could speak to specifically how you kind of are working with clients in regards to these. Please, Leanne.
Well, really, the urgent thing that we're working on right now for ACA are the ACA tax forms. There's two new tax forms that are required this year for large employers to complete, and we are completing those as a courtesy for our clients, and those are really the hot topics. And we are communicating to our clients as well. We are starting to receive calls saying that employees are going to their employers saying, you know, I would need to file my taxes and I don't have this certain form, what do I do? And so, you know, part of our job is getting that communication to the employers and to the employees saying that, no, it's not required for you to have this particular form. You can file your taxes, and this form that we are sending out is for, basically for their records.
Yeah, absolutely. You know, Sarah, you mentioned, I'm going to borrow from you a quote, which is that it takes more time to not have a strategy. Do you mind kind of going into that a little bit more?
I think when you had a strategy, usually you've taken some time to look at all of the pieces that may or may not apply to you. And you know, if I ask Tom a question, or if any of you ask Tom a question about the Affordable Care Act, a lot of times the answer is it depends. So having a strategy means that you work through all of those cases where it really depends on, you know, where you're covered, if you're covered, are you a large employer? Are you not? Which of your employees are you required to offer coverage to? If you haven't thought through that in advance and really created a strategy, you're going to spend more time on the back end and more money, maybe in penalties, maybe in technology and systems that you'll put in place for next year, but not in time to help you for this year.
And it'll definitely impact your ability to implement that strategy. And where you're
right, and for companies that we aren't providing this form for, if you haven't started that yet and you haven't developed a system months ago on how you're going to track this information, then you're probably in trouble and you're going to have a lot of late nights ahead of you.
You know, before we jump to our next question, I just wanted to make it a point. We're starting to see a couple questions come through, and we will address those questions at the end of the conversation. So I don't want you to feel like we're not going to, but we will. So, Tom, I'm going to start with you with this question. What are the most important things to know?
Well, I like to start upstream at the beginning. There's kind of a chronology that I look at compliance for the Affordable Care Act, and I think one of the most important things to know is whether and when the law applies to you. Now, some employers clearly have over 50 or even over 100 employees, full-time employees, or full-time equivalents in any combination. And so that's not too big of a question for them. But if you're close to 50 or a little bit above or a little bit below, knowing how the exact rules work is a really big deal. You can waste a lot of time setting up systems in place if you're not subject to the law. A really good example of that is people don't understand. There's a very complicated set of scenarios one's called controlled groups and another is called affiliated service groups. And these are scenarios where groups of employers with separate tax ID numbers, separate legal entities, have to be treated as a single employer for the purposes of determining group size to determine whether the law applies to them or not.
Can you clarify that just a little bit more? So if you're a business owner and you have multiple different businesses underneath you,
right,
and there's common ownership.
Yeah. So any discussion of this that isn't like a graduate level class taking a week is going to be an oversimplification. But generally speaking, for the control group, 80% is generally the magic number. Again, I have to heavily disclaim this, that there's more to it than this. But so let's say you own a series of sandwich shops throughout town. Okay. Each one has 15 or 20 employees, but that's it. You could, a reasonable person would say, oh, well, each of these are small businesses. They have their own tax ID numbers. I run them separately. But the IRS doesn't look at it that way. They consider that a loophole, frankly. They say someone has a common ownership or that someone has a significant ownership in multiple businesses, then they all have to be counted together. Otherwise everybody would divide up their businesses into all these different sub-pieces just to avoid laws. And this applies to COBRA and FMLA and other laws too, not just the Affordable Care Act. So a classic example is I'll talk to somebody, I'll bring up the controlled group rules, and I'll say, do you own any other businesses? Do you have any subsidiaries? Let's talk about all this. Like, no, I talked to my accountant about this. This is all taken care of. And then I say, well, what about this other business that your wife mentioned? And says, oh, that's not my business. That's my wife's. And I'm like, well, I've got bad news for you, because you're married. You own. You both own what each other owns. So there's a lot of people right now, who may not even think that the law applies to them that it does.
I'm sure there's a lot of that in reserve control groups being just one of many. Delays, forms, plan years, or other opportunities that we could dive into. Leanne, would you mind diving into another one of those for us?
Well, another example that you just have to keep track of things as they come along, and it's ever-changing. For example, these tax forms, there was a delay. There are certain parts of the law that hasn't fully been enacted, and there's been delays in the Cadillac tax. And so it's something that you really need to keep track of, and it seems like it's really not set in stone, and it's a new fairly new when you think about laws. It's a fairly new law that is still, I think, evolving in a certain way.
As far as important things to know, another one of these things where common sense would dictate to someone who a full-time or part-time employee is. A really big part of this whole law is the IRS definitions of what a full-time employee is, and the IRS has two definitions, two methods that you can use to determine who is full-time versus part-time. And one of them is pretty straightforward. It's called the monthly measurement method, and I could explain that pretty quickly. It's kind of simple but cruel and unforgiving. Then there's a much more complicated but generally preferable method called the Lookback measurement method. Okay. And so a person who's just kind of casually grazing the rules or whatever, even the IRS instructions, if you're using your own internal business's definition of full-time or part-time, that's not going to fly here. We're running into that now a lot, where the coding of the forms is kind of pulling the curtains aside and shedding light on a lot of businesses realizing that these complicated rules aren't common sense. They are the rules, and they're realizing that they've made a lot of mistakes over the last year because they just didn't dive deeply enough. So that understanding of either the look-back measurement method or the monthly measurement method, I think, is a really important piece to understand. Thank you.
From an HR perspective, I get this question a lot when we're reviewing, status definitions of full-time and part-time, and the Affordable Care Act defines full-time just under the Affordable Care Act regarding who is eligible for your medical insurance plan. So companies sometimes have different definitions, of full-time under your medical insurance plan and then full-time under your time off plan or other benefits. So it can get a little bit confusing. And really working through that process and defining who is eligible when is a good exercise.
And to add to that, really, who's eligible when, also you have to take into consideration breaks in service, if they've been rehired, if there was a status change, and all of these have specific rules that surround these different types of employees. So it's definitely a very complicated just to say who is full-time.
A lot of communication needs to happen as part of your strategy, and then implementing that strategy to be compliant. Communication regarding how employees file their documents. You started down that path of tax forms and things along those lines. Can you highlight a little bit more on some of the other documentation that may need to be, incorporated into this overall strategy and implementation of that strategy?
Sure. One of the things the Affordable Care Act did that I think a lot of people haven't fully embraced yet philosophically is that the Affordable Care Act made offers of coverage a tax issue, okay? And that's a pretty radical change. So there's all kinds of, when you complete your forms to attest to the IRS the extent to which you did or did not meet your obligations under the law as a large employer, within that attestation, there's basically 4 things that you are claiming that you need to prove if you're ever audited. And this isn't Affordable Care Act rules. These are IRS rules. Anytime you submit a tax form to the IRS, there are rules about record keeping and substantiation that says if you're later audited and you can't prove what you put on these forms, then you've got a problem. Then you may not be able to claim those things even if it was true. So the 4 things are, is your coverage minimum value or not? All the codes are tied to that aspect. That's one of the easier of the 4, frankly. Next thing is the affordability, which is a huge issue. We could have a whole hour conversation just on affordability, frankly. But documenting why it is you're saying that this coverage is affordable for these employees. When you do your forms, you're coding it to say, this person waived coverage, but it was affordable under the FPL safe harbor, or the rate of pay safe harbor, or the W-2 safe harbor. You need to be prepared for 7 years to prove and substantiate why you said that it was affordable for those reasons. The third one is by far the most cumbersome, which is proving who's full-time and part-time in any given month. Now, I'm not aware of the IRS or anyone getting in trouble for offering coverage to somebody that didn't have to. The people we're worried about are the people that you didn't offer coverage to, or you offered coverage that wasn't affordable. So you have to be able to pull out the average hours over the measurement period if that's what you're using, or whatever the data is you need depending on which method you're using. You have to prove that I didn't offer coverage to this person because they were part-time, and they were part-time because of this math that I'm showing you right here. That's a really big deal. And keeping the records for 7 years is also something that's required. Most people don't really realize that. The fourth thing that I mentioned before, the fourth thing is the offer of coverage. If somebody waives coverage, it's never been more important to have a signed, dated waiver, because what's going to happen is that, and I'm actually hearing stories of this a lot right now, is that an employee will receive an offer of affordable coverage, and that offer makes them automatically ineligible for a subsidy on the exchanges, not only for themselves but for their families. And that's a big surprise to a lot of people. They may understand that it's affordable to them, but they disagree vehemently. It defies common sense that it's affordable for their spouse or their children or whatever when they look at the total. So they go to the exchange and they get some sketchy advice. We were hearing a lot of reports of that. They're instructed to fill out the forms or to answer the questions in a certain way. They're coached, in other words. And they get a subsidy. Now, maybe a year has passed. Now these forms are going through, and all of a sudden, the IRS is going to get the form from the employer saying they were offered affordable coverage, see that they got a subsidy, and say, you were ineligible. You're going to owe us $10,000 or $18,000 back for last year. Yeah. And that's going to wreck some people's lives, right? And I could see an employee, even a great employee, saying, but was I really offered coverage? I mean, now that I remember that day I went to the meeting and then I got sick and I stepped out and threw up and then didn't come back. Are you sure I was really offered coverage? I could see those things happening. So it sounds silly. It sounds crazy to say, oh, the law doesn't require you to have a signed waiver. Right. But if you don't, and a person, then it's he said, she said, and you could be in a lot of trouble. So it could save you a lot of heartache and get yourself out of hot water just by documenting and keeping all this stuff.
We were talking about that. You're starting to head down that overlooked and surprising things, which is the next question.
Sure.
But before we head to that question, and since I happen to be in the driver's seat here, I'm going to go ahead and just pick up this question that was submitted before we move on to the next section. So the question is, how do nonprofits factor into a control group? Absent common ownership, what are the factors that would create a nonprofit, quote-unquote, control group from the ACA perspective?
Sure. So it's very possible for a nonprofit to own another entity. So, for example, we have a lot of hospitals that are nonprofits, but they might own a clinic or something like that. So sometimes it's very obvious. It's very analogous to a business owning something else. I'm aware of at least one situation where multiple nonprofits went together to kind of run a separate entity that runs conventions and things like that. So a lot of that you look at control, basically. So it's not ownership per se, but it's control. So, and I'm oversimplifying this, by the way, I'd like to point out. This entity that I have in mind, for example, they had part of the organization of this third entity, they had control over who is on the board of that third entity.
Okay.
They got to place those people. That wasn't something that the entity itself could do, and that was their method of control. And that was deemed this is actually a COBRA issue, not ACA, but that was deemed similar to control. That was ownership. So you look at control, not necessarily ownership. That's a very complicated and gray area, especially when you get into government entities or church groups, because the rules actually are a little different for those. So depending on what type of nonprofit, whether it's private sector or fourth sector, it depends.
I was waiting for that. So it might be it depends, and whether you're a client of Merit or are thinking about such, call Merit, and we'll work with Tom and others in order to make that happen. So we're going to move on to the third question here before we get into kind of some of those recommendations that we'd have, and then the other questions that have arisen. What are the most overlooked and surprising aspects? Sarah?
Yeah, I think for me, one of the most surprising aspects was the first time I went to a seminar about how to complete the forms, so the 1094 and 1095. I think I came out, I felt a little ill when I came out. I think that was really the first time I realized how much more sophisticated employers need to be with their record keeping and data, because of the information required to fill out those forms. It may be housed in different systems that don't talk to each other.
Yeah.
It may be housed in your paper files. Maybe you didn't realize exactly how much detail you needed. So I don't know, you may have to go dig through every single one of your employee files for 2015 or 2014, whatever you're reporting for,
Yeah.
in order to pull the information. You got to know who was covered and in what month and what dependents were covered and when coverage was offered and how much the most affordable plan was every month that they were offered coverage. So there's a lot of data and information, and really thinking through that, the depth of that and how many places and how many people would be involved in getting that I think that was, for me, really the most surprising aspect of this.
For me, I think one of the things that most people overlook is we often, the law does have an individual mandate. The law does require individual taxpayers to purchase insurance for themselves. But the way the employer mandate, and I'm using air quotes, you can't see right now, but the way the employer mandate is written, it's really actually not a mandate. It actually does give employers a choice. That's why we call it play or pay. And what's surprising or overlooked to a lot of people is it's very easy to get swept up in the rules and say, oh, well, the law defines full-time as 30 hours and you have to offer coverage and all that. Mm-hmm. You don't have to offer coverage at all. You can define full-time at 40 hours. You can do things the way you've always done them for the most part. But you just have to understand that you're exposing yourself to some penalties. If you're, there's some excellent reasons and times where your strategy should not be to follow the letter of the law, that you should say, we are going to class out this small group of people because we know they're not going to, because they just don't bring enough value to justify a benefit. A great example I can think of is on-call hours. If you're paying someone for on-call, and there's other reasons even when you're not paying them, you have to count that as an hour of service, even though they didn't get called in to work. So you might have a security person or a nurse or something like that. Yeah. They might work 10 hours a week, but they're on call 20 hours a week. The IRS deems that a full-time employee, okay? So it's important to understand that rule, but there might be situations where it's better business sense to pay and not play, to be willing to not make that coverage affordable or maybe even class out that type of employee, and understanding with your eyes open, doing a cost-risk analysis, of course.
Yes, of course. When it comes to the strategy aspect and the implementation, you're definitely touching on that. And Merit is working with its employers on defining what the strategy will be with their particular business, and then going about that implementation. Leanne, would you mind sharing us maybe a story or some information about how you're working with the clients here on enabling them to do so?
Yes, well, it first started with just an education of our clients as far as what is ACA and what are some of the basic rules of that. And during open enrollment of last year, we spoke to our clients about the different aspects and their tracking, and we reviewed with them as far as who's full-time, who was not, and for these people that you may have classified as part-time, and they actually, after the look-back method, they ended up being full-time. Should we offer them coverage? Do we have to offer them coverage? Are they maybe some employees that are within that wiggle room? And so those are some of the things that we worked with our clients with. And of course, right now we're working with them as far as the tax forms. But really, it's an ongoing basis that we are constantly reviewing with our clients.
Perfect. Now, a question from the audience would be, does Merit take care of all of the record-keeping, reporting, and documentation required for the ACA for compliance? Now, I have a feeling that question is, it depends on what those record-keeping, reporting, and documentation requirements are. But a majority of those aspects are covered. Do you have any more to offer as it relates to?
Well,
go ahead.
I would say that we have what we have, and we may not, depending on what we provide as services for our clients, will depend on what information we have and we store in our system.
That's perfect. Yeah. So it depends.
Yeah. Sorry.
It depends on the service model. We work with our clients each differently.
Right.
And each client's going to get a customized and flexible approach to how they're going to be held, covered, so to speak.
Right. And that's something definitely when we take on new clients, we have that discussion with them as far as for the services we provide. This is what we house in our system and what we can handle.
I would suspect that how open and communicative the Merit client is with Merit has a huge role in that as well.
Thank you. Yes.
I've been involved in a couple of situations where someone had to reduce hours because of a medical condition, but that information was never relayed to Merit. So they couldn't really help them be compliant with, FMLA or ADA or whatever because they weren't given all the facts and circumstances to do so. So I think that my experience with Merit is that they do the lion's share for most of the clients based on the relationships that I'm aware of. If the medical is client retained where they aren't using a Merit medical plan but they've gone outside and are doing that, I think a lot of the burden then probably shifts to the client because of that decision. And I can think of other examples where you can't just say, oh yeah, Merit does everything, because sometimes they just that's impossible, and ultimately it's the employer who's sponsoring the plan is the one who's responsible for a lot of the compliance.
Very hand-in-glove relationship.
Yeah, I mean, for my wife, I happen to know her organization. I won't drop names, but she runs a nonprofit, and it is hand in glove with Merit, and Merit is, as far as I can tell, doing everything and doing everything beautifully.
Perfect. We touched on a lot with that particular question, and every question that we have during this conversation can only go so deep into the levels of which you're going to need to understand, and we hope that the conversation will begin to spark questions, spark thoughts that you can bring back to us, whether it's today or down the road. Now, what recommendations would the audience find most valuable? Tom, I'm going to come to you.
Okay.
Let's get this rock and rolling here.
Sure.
We're going to look at this from a few perspectives: the reassess and realignment aspect of your situation, the strategies, so on and so forth.
Yeah, I'm glad you brought that up because a lot of people, because it is a lot of work to learn the rules and to come up with a strategy and then to implement it, they've invested so much in that they forget that they need to revisit that on a regular basis, at least I would say annually, but even ongoing throughout the year. So just a few examples. If you have any sort of merger acquisition sort of activity at all, I would say that is a huge red flag that you need to look at things and see how that affects the way you're doing things, and maybe what was a great plan then needs to be modified or changed now that your circumstances changed. Also, workforce changes can be a big role in that. And my personal kind of what I help a lot of people with is the pay or play strategy that a lot of employers have been choosing to make some coverage unaffordable. They're okay with that. They're making it unaffordable with the understanding that very few people, especially in the state of Iowa, who are eligible for subsidies are actually getting subsidies, okay? And what's going to change is that Wellmark is planning to join the exchanges in 2017. That's going to radically change the math and the likelihood of that's going to increase the number of people who are getting subsidies on the exchange for 2017. So it might be working great for 2015. It might be working great this year. If you're not thinking already of how you may need to reassess the risk of triggering a penalty could be because of Wellmark's entrance into that. You've got your head in the sand. That's going to be a big deal, and you need to revisit all that stuff every year. Minimum.
That means your record keeping has to be better and better every year, so you'll be asked to prove a lot more often what kind of coverage you offered and who.
Absolutely.
And not only do you have to reassess on a regular basis, but you have to really think about ACA continually, because let's say you have a part-time employee and you fully intend them to stay part-time. However, the part-time employee is covering for this person during a maternity leave or working extra hours on a special project, and what you may find out after you do your 12-month look back is that person on average worked full-time, and that was not your intent throughout the year. And so that's something that you really need to keep track of. If you fully intend to have this person be a part-time person and stay part-time, and you have no intention of offering benefits, then that's something on a regular basis you'll need to keep track of.
I think a really important thing to ask, especially once you've gotten your processes and your systems in place for a while, is to reassess regularly and ask, maybe our strategy was great, but how was our execution, and did we bite off more than we could chew? Maybe our strategy was too sophisticated for us to handle, and we need to pull back a little bit and maybe simplify things. And that may cost us more money in the long run, but maybe it's safer to do that so we can budget for it and plan and so forth. So I think a really good example is people using the look-back measurement method for all employees. We have a lot of clients now who are revisiting that and saying, you know what, for our salaried people, we didn't need to go through all this. They're all offered coverage. It's affordable for all of our salaried people. Maybe we should have used the monthly measurement method for those. And there's some little tweaks like that should be happening, I think, over time.
I'm going to combine a couple of questions that we've had submitted here during the conversation. So I'm going to say this in two parts, and I'm going to let you all decide how to best answer this. First part, we haven't decided if we are using the look-back measurement method versus the monthly measurement method. Is one better than the other? Before I move on, if we choose a look-back period for employees to be benefit eligible, will merit help us track that? So I don't know if you can combine those questions into one answer, but and I'll keep track of making sure we do answer those.
I can answer the first one anyway.
Go ahead.
Yeah.
And that question is, if we haven't decided if we are using the look-back measurement method versus the monthly measurement method, is one better than the other?
Yes, the answer is one is better than the other. The question is which one. For some employers, one is better. For some employers, the other is better.
Okay.
So very briefly, the monthly measurement method is very easy to administer. It's very unforgiving. Anyone who actually earned 130 hours of service or more in a calendar month is full-time for that month, as far as the IRS is concerned. Anyone who did not hit that 130-hour threshold in the calendar month is part-time, and that's the whole story behind it. So if you have just full-time and just part-time people, you don't have people covering shifts, you don't have variable hour or seasonal people or people who work full-time for a series of months and drop to part-time. Things are like, we have a lot of white-collar clients that just have full-time people. They don't even have any part-time people at all. The monthly measurement method works just fine for them, and that would be better because it's simpler. But if you're looking at retail, or if you're looking at something where you don't have as much control, I know a lot of HR departments that don't know what somebody worked. I mean, they know it was scheduled, but they won't know it was actually worked till the time cards are already run, and that's too late to do anything about it. And so if you have a lot of seasonal variable hour, the more turnover you have, the more people you have that work for you that are not benefit eligible, the more likely it is that the other system, the look-back measurement method, would be better. So that's exactly, I would say that requires a great amount of analysis. A lot of questions have to be asked. That's something that I would say most employers wouldn't probably want to do on their own. That's a good reason to get a broker or Merit or some other resource like that to help them figure that out, because there's a lot of variables that need to be considered.
Thanks, Tom. Now I'm going to ask that other question, the other second part. If we choose a look-back period for employees to be benefit eligible, will Merit help us track that?
Yep. Most of our, I think by far, or maybe all of our clients are using the 12-month look-back period. Right. That corresponds with our plan year, so we can line up those new offers of coverage with the plan year and open enrollment time. But I think we have some tools in place that allow us to do the analysis. We have special reports built that we can pull at the end of that period that will flag any employee who wasn't offered coverage, who maybe should have been, or those we need to look at and do a deeper dive on.
Yeah.
So we do that's really become part of our process, and most one of the conversations we have with our clients at open enrollment time, and typically when they come on, or at the time we determine, I think our benefits department just completed an analysis of who is, to our knowledge, anyway, absent control groups we know about, who is subject to the law.
Yeah.
So those are some things that we think about all the time, and we go through and we help make sure we have that conversation and help. We can't do everything, but we can really do a lot of the heavy lifting and continual analysis for our client companies.
It seems to me that right now, because the law is so early, a lot of people are still stuck in the first of those 3 phases that you talked about at the beginning, the education phase, the learning what the rules are. Mm-hmm. If you do that, if that foundation is strong and you build a good strategy, and that's kind of where merit comes in. If you have a good strategy and you are confident and you know that meets the letter of the law and is compliant, you can start forgetting about the actual federal rules, and you can just focus on your systems and processes. So if you have a checklist that you've developed that you know is compliant with the rules, mm-hmm. you can forget about the rules if you have faith in that checklist. And that's something that merit helps with a great deal. I've seen that.
And not only do we help with the checking of the full-time and part-time employees, but really, as Sarah said, who is a large employer, and that may change, and that's one thing that people may not realize is that, okay, in 2016 I'm considered a large employer, but I have decreased in size and workforce, and so the following year I may not be considered a large employer, and the rules may not apply. So that is something also to consider that could change through time.
And the original question, which was, what recommendations would the audience find most valuable? And it sounds to me like, just getting the proper understanding of where and when you need to be compliant, mm-hmm. and ensuring that you have the checks and balances in place to just put it on, so to speak, an autopilot, with the exception of being able to come back and review that and assess your strategy along the way. And that's what Merit can help out with. That's what other resources that exist that can help out with. Now, I have we're being cognizant of the time here, and I have one question here, and I wanted to wait till the end to say it. It's tell us where we can find more information. Leanne, you've provided me in the past some details, if you don't mind.
Well, one resource that I feel is good for employees or employers or just wanting some basic information is the Kaiser Family Foundation website. It's a great website that gives you just some history and some background and basic knowledge that has great graphics, and it spells it out in very common language, and it gives you a really great start.
Thank you.
From an HR perspective, I like to go to the people who are going to penalize me for things. Say, if you walked in the door, would I get in trouble for this? So, I go to the IRS a lot, the Department of Labor a lot for the regulations that really apply to me, and the enforcement interpretation, because regulations are one thing, but how they're going to enforce them and when are sometimes a little bit different thing. I also, at Merit, we call Tom. So, but to that point, getting a good expert who can answer those "it depends" questions, because those are the questions that are really hard to find the answer to online, because they're very situational, and getting a good expert lined up to help you work through those will save you an incredible amount of time and money.
You bring up a good point, and that's that expert. And we oftentimes, as business owners out there are often looking to a CPA or an attorney, for certain guidance. This is just as heavy. This is just as hard-hitting as any of those. So, Tom, please carry on with where other resources we can.
Well, yeah, I'll give you my secret weapon in a second, but I did want to add on to something that Sarah said, which is that an expert I'm glad you used the word expert, because I think when you go to a lot of other sources, including accountants and lawyers and things like that, not to disparage them, because they know all kinds of things that we would never know, or not be qualified or licensed to talk about. But it's my experience is that I could leave and come back in 15 minutes and line up 20 people who could spout off true facts to you. And that's helpful to an extent, but that's not really what most people need. People need analysis. They need interpretation, enlightenment, judgment of what is important for you to know or not. And that's, I think, the hardest thing to find. That's what, to me, an expert means. Some people confuse it with people who know what the rules are, and that's not good enough. They have to be able to translate it and communicate it and kind of process it for you, so you can use that information in a reliable source. So that leads to my actual answer to your question, which is where do I go? I have a secret weapon, and I have a caveat, okay? So I'll tell you what it is, but you have to listen to everything I say about it, because there's an important thing that you need to know about it. So anytime I need to really know the answer to one of these questions, right now, because the law is so fresh and there are lots of court cases and things that change over time, the final rules that were published on the Federal Register are a fantastic resource. That is where everybody goes for the final word on if something is allowed or not, or what the actual rule says. So if you Google just the phrase Federal Register and 4980H or employer shared responsibility, I think you could find it pretty quickly. If you get good at terminology, you can search through it. And just so you know, it's divided into two parts. Most of it is what's called the preamble, and that's a discussion of the rules. And from most of the time, that's what people need, and you can get the answer there. They'll often say things like, oh, commentators requested that we have a rule that worked like this, but we said that we can't for this reason. So it kind of brings context and kind of processes it for you, which I think is very helpful. If that doesn't answer it, then you go to the actual regulations, which is below that, and that's the legalese written by lawyers for lawyers, which is just the way it's worded, and sometimes you have to go there. Yeah. So now my caveat, what I want everyone to understand about that, this stuff is complicated. These regulations are complicated. If you go in and look for the answer that you want to be true and then find it and then close out your window, I promise you're probably going to get yourself into a lot of trouble, because you'll have the only thing worse than not knowing the right answer is knowing the wrong answer, right? So it might very often it will say something that is music to your ears, and then in the next paragraph it takes it away. It basically unsays it, or it adds so many caveats. I call those Hotel California provisions. You can check it anytime you want, but you can never leave. So if you only say, oh, we can check out anytime we want, woohoo, and you pop the champagne bottle, then you're going to get yourself in a lot of trouble. Read the whole section. If it's about affordability safe harbors, find that section. Don't just read the part that you want to read. Read the whole section, because there's all kinds of surprises.
Thank you. You know, again, coming back full circle, it depends was the start of the conversation. And if you're looking through these resources and you're starting to wonder, what exactly am I getting into, again, utilize the experts around you. Now, we'll get the links that were referenced here on the solvingaca.com website. If you've got questions, you can submit them through that website. If you need resources, you need somebody to talk to, we're available here, and we can connect you with whomever would give you the best answers and the best to address your current situation. So we're going to wrap this up. Wonderful discussion. Thank you all. For those listening, you'll likely have more questions. Love to see and hear what those are. We'll have this recording on solvingaca.com, so be sure to visit. Thank you.
Thank you.
Thank you.